All right, hello everyone. Welcome to week 12, and we will be talking about the criminal trial and sentencing portion of the trials. So I know that you guys are not used to being online, so what I will do is I will timestamp this presentation so that you can go back and watch sections if you need to do that or something like that, or if you missed something. Also, please make sure you take notes like you would in class. This will count as the presentation for this week as we kind of wrap up our experience of the courts and go through the sentencing phases. All right, with that, let's go ahead and get started. So it's important to kind of look at the types of trials that there are. The majority of what we've talked about are criminal trials, and these are trials used to ascertain the guilt or lack of guilt of defendants charged with committing crimes. Estimates range between 2 and 10% of criminal cases go to trial. So remember, we talked about plea bargaining, and realistically about 90% of cases are pled out. So you still have about 10% that go to a criminal trial. And the purpose of these criminal trials is to ascertain legal guilt or innocence. So there's a difference between legal guilt and factual guilt. Legal guilt is the prosecutor being able to persuade a judge or jury that the defendant is guilty. Factual guilt is whether the defendant actually committed the crime, because we know that sometimes people can be factual or legally guilty, but not factually guilty just because of the persuasion of the prosecutor. Then we have civil trials, which are used to settle disputes between two non-criminal parties. And think of these trials as like divorce, child custody, money disputes. Then you have traffic hearings, which traffic hearings are the most common type of trial in the United States. Again, traffic hearings are your most common type of trial in the United States, and they're used to deal with traffic offenses. The majority of criminal cases at the federal and state levels are adjudicated by a jury. And so in order to understand that jury, the adjudication means that they render a formal judgment about a disputed matter. So those typically happen in jury trials. And last week we talked about selection of the jury and the importance of the jury. So not all trials are jury trials, though. Some are what we know as bench trials. And a bench trial is a trial that does not have a jury, but the evidence is actually presented to a judge, and the judge is the finder of fact. So why would you opt for a bench trial? Well, it may benefit the defendant in trials that are complicated or have technical issues. It could be faster, just because you don't have a jury to kind of persuade. You're just kind of laying out the facts for the judge. And sometimes there are a panel of judges. So you have more kind of experience levels of the judges to kind of hear nuance issues. So if your defense is going to be really nuanced in the law, it might be more beneficial for you to opt for a jury or for a bench trial than a jury trial, because the judge knows those nuances. So your book lays out perfectly this figure that I really like, and I wanted to include. This is the sequence of events during the trial. Please make sure you know the sequence of events. We will talk a little bit about the sequence of events, but your book goes into greater detail. So you will see that at the beginning of the trial, you have opening arguments from both the prosecutor and the defense attorney. Then you go into the presentation of evidence and witnesses and things like that, which is what you think of as the trial. Then you have closing arguments. evidence by both the prosecutor and the defense attorney. Then you have something known as the judge's charge to the jury. And we'll talk about what that means, but essentially that's jury instructions. So after the jury gets their instructions, they will go into what are known as deliberations, and that is where they go into a room by themselves and kind of go over the case and determine whether there is guilt or innocence. Once they decide, there's a reading of the verdict, and depending on what the verdict is, if the defendant is found guilty, then there'll be a sentencing phase to the trial, or if the defendant is acquitted, which means not guilty, then that's where it ends. All right, so let's start at the beginning and let's talk about opening statements. The purpose of opening statements is to offer a picture of what transpired. You don't really present evidence, but you kind of tell the jury what they can expect to see. Typically, your prosecutors go first in opening statements because they have the burden of proof to prove beyond a reasonable doubt that this defendant is guilty. Counsel can only state what he or she expects to show as evidence or what the evidence will show during the trial. The judge typically will instruct the jury that opening statements are not evidence, but a prediction of what the evidence will be presented. There is no formal rebuttal in opening statements, but the defense does have an opportunity to rebut assertions made in the prosecution's opening statements because they go after the prosecution. So after opening statements, we go into the presentation of the evidence. And we're not going to get too nuanced into evidence as that's a whole like criminal law, criminal procedure aspect that you will take if you're a criminal justice major. But evidence is the material or the witnesses that will be presented at trial to either reinforce the prosecution's evidence or to rebut with the defense. So there are federal rules of evidence. You can't just bring in everything. There are guidelines that are set up as to what evidence can go into what type of trial, and that is known as the federal rules of evidence. This guides what constitutes evidence and what can be introduced at trial. And the thing that you really have to remember is evidence has to be three things. It has to be relevant, it has to be material, and it has to be competent. So what are different forms of evidence? Well, evidence can range from witness testimony to written or electronic documents, DNA, photographs, crime scene pictures are typical evidence, and things like that. Evidence typically is categorized into two different categories. So the first is direct evidence. Direct evidence doesn't require the fact finder to draw an inference. So direct evidence, there is no guessing that evidence or drawing your own conclusions as to what that evidence says. It is legitimately showing you the actual events. So like a video of the suspect murdering someone would be direct evidence because you don't have to draw inferences from that video to link it to the murder. You can actually see the murder with direct evidence. Circumstantial evidence, however, requires that the jury or the judge or whoever's taking in that evidence interpret the evidence and draw a conclusion to how that relates to what the person is charged with. So, like forensic evidence, a fingerprint analysis would be considered circumstantial evidence because it isn't direct. Like, you have to infer that that fingerprint was on the door that was kicked open that led to the perpetrator gaining entrance into the house to murder the victim. So you have to draw those inferences in order to determine that the suspect murdered someone. There's also a type of evidence that is known as hearsay. Now, we talked a little bit about hearsay in the pre-trial activities, but we're really going to kind of talk about hearsay here. So hearsay is any out-of-court statements offered in court to prove truth. And there is a general rule of hearsay, and that is that hearsay is inadmissible in court. So hearsay is really your third-party information. Like, I heard that so-and-so was in this area. Or I heard, or Johnny told Lindsay that he killed Peter, and then Lindsay told me. So I don't have direct evidence that Johnny killed Peter, but I have hearsay evidence because Lindsay told me that Johnny told her that he killed Peter. That's typically frowned upon, and it is highly inadmissible. In normal trials, you cannot have hearsay evidence. However, as we have talked about, there are exceptions to every rule in criminal justice, and there are over 30 exceptions to the hearsay rule. I want you to be familiar with 3 of them. So the first is the dying declaration. This is the final words of a crime witness, or a crime victim. So the dying declaration allows the dying words of a witness to a crime to be used in court. So if Johnny told law enforcement that he physically saw Peter stab Lindsay, and then Peter turned the knife and stabbed Johnny, and the paramedics came and Johnny said, Peter stabbed Lindsay, and then Johnny died, the paramedic could testify that he talked to Johnny, and Johnny told him that Peter stabbed Lindsay. That is considered a dying declaration. Another exception to the hearsay rule is known as excited utterance. An excited utterance is a statement made by a person during a shocking or upsetting event. So these are the words that are blurted out during the stress of excitement, may be entered into court as evidence. And then you have reputation concerning character. That is an exception to the hearsay inadmissibility rule. This allows witnesses to testify under oath about the reputation of a person's friends and acquaintances. So those are the 3 main exceptions to the hearsay law or rule. Otherwise, know that hearsay is not admissible in court. All right, so let's talk about closing statements. So once everyone presents their evidence, they go into closing statements. And the purpose of closing statements is to summarize the evidence and arguments for the jury. So in a criminal trial, the prosecutor presents evidence to support their case first. Prosecutors engage in direct examination of witnesses. They can't make a witness testify because a witness does have a Fifth Amendment right. The defense can cross-examine witnesses called by the prosecution, and then the defense gets to put up their witnesses and their evidence, and then we go to closing statements. And that is basically where each side kind of summarizes their arguments for the jury, kind of try to tie it in a nice little bow. People may state with inferences what inferences can be drawn to the evidence presented in trial, but no new evidence can be introduced during closing statements. So a famous closing statement is Johnny Cochran's closing statement with O.J. Simpson, where the prosecution introduced the glove that O.J. Simpson supposedly wore whenever he allegedly committed the crime against Nicole Brown. So his famous closing statement was, if the glove does not fit, you should acquit, because what had happened was the glove, they had O.J. try on the glove in the trial, and the glove did not fit. And so Johnny kind of brought that back to the jury's attention, that if this glove was used in the crime, there's no way my client could have committed the crime because the glove doesn't fit him. So closing statements are the last opportunity for everyone to kind of wrap their arguments up and kind of correlate and persuade the jury of what the evidence says. So after closing statements, the judge will give a charge to the jury. So your book calls it charge to the jury. You will also hear it as jury instructions. So this is where the judge will instruct the jury on the legal aspects of reaching a verdict. So this is where the judge will go through the different counts of that the defendant is charged with, and kind of remind the jury what has to be satisfied for that count to be relevant. So the jury has to find this count guilty if the prosecution has proven these facts. We typically use pattern jury instructions, which I have actually provided in folio this week. You can go through and look at some examples of pattern jury instructions. These are just forms, like they are templates that use in charging instructions. The charging instructions generally will note that the defendant is innocent until proven guilty. Remind the jury that the standard of evidence has to be beyond a reasonable doubt. That is the level of proof required in criminal cases. There cannot be a question of innocence left, or they have to acquit. And then they'll also remind them that they have to be objective, that they can't already have made up their mind. Make sure you check out some of the pattern forms. They're very long documents, because I think I actually got it from the Georgia Superior Court website, but it's a huge packet, so you can go through and kind of look at the different jury instruction templates that there are that we use. So once evidence is presented and the closing statements are done, the case is then handed over to the jury to do what we call deliberation. And deliberation is where the jury goes back and kind of goes over the case with themselves. They typically will elect a foreperson who is responsible for kind of talking for the jury. They're the face of the jury. So with deliberation, the jury is deciding the guilt or innocence of a defendant. Jury cannot be contacted by anyone from the trial during deliberations. If there's a question, they have to ask the judge via a written note, and both parties, the defense and the prosecution, has to be in court when the judge reads it, so that they both know kind of what the jury is asking. Deliberation can take anywhere from minutes to weeks to months. It just depends on the type of trial, where the conversation with the jury is, and all of that. During deliberations, juries are typically sequestered, which means they don't have any outside influence. I will say you will hear, and we'll talk about it here in a minute when we talk about hung juries, but I have it listed under hung juries. But there's something called an Allen charge. And an Allen charge is basically if the jury is deadlocked and can't really agree and they need further instructions, the judge is able to give them further instructions through what is known as an Allen charge. And that kind of helps them further clarify any questions that they have. So what decisions can a jury come up with? Well, first, they can come up with a guilty verdict saying that, yes, all counts are guilty, or some counts are guilty, some counts are not guilty. If they find the defendant not guilty, we call that acquittal. So the defendant would be acquitted of all charges, which means that the jury basically says there is not the evidence beyond a reasonable doubt to suspect that this person actually did what they're accused of, so we are letting them off. A jury is made up of people, and people have various opinions, and sometimes it's not as standard or black and white as guilty, not guilty. Sometimes there are different opinions on different charges based on the evidence that's presented. And so sometimes juries become deadlocked, which means they can't agree upon the guilt or innocence of the defendants. Like, half of them say that they're guilty, half of them say that their defendant is innocent, and they're at an impasse. They can't render a unanimous decision, which is typically required for criminal cases. Therefore, a mistrial can be declared. They will typically if the jury is deadlocked, they will typically bring them in and do the Allen charge, which is the further clarification, which is why I have it under that. But if a jury is truly deadlocked, or hung jury as we call it, then the judge can declare a mistrial. And a mistrial means that the trial ends prior to the normal conclusion. The jury can also do what is called jury nullification. And jury nullification is a highly controversial issue. And essentially, jury nullification is the ability of the jury to ignore the law and acquit a guilty defendant. And if the jury nullifies, basically double jeopardy comes into play. And so when would jury nullification happen? So if the jury didn't agree with the law and wanted to prove a point, the jury could nullify and acquit a guilty defendant. So like if you went to a jury trial on marijuana charges and the jury decided that they didn't agree with the strict marijuana laws, so they are going to acquit this defendant as a form of taking a stand against the law, then that would be considered jury nullification. That defendant can't be retried by the same sovereign, which means that the same like district attorney can't try them again. There are some exceptions. If there are different elements that are available with each crime, or if there's a different jurisdiction that can try this case, then that can kind of skirt around the double jeopardy. But that defendant, once acquitted through jury nullification, can't be retried for that same crime with those same facts in that same jurisdiction. So once a jury has made a decision, you go to the reading of the verdict, which is a formal courtroom event where the jury offers the verdict on the charges. All parties have to be in the courtroom. So the defense, the defendant, the prosecutors, the judge, and then all of the jury members have to be in the courtroom for the jury to read the verdict. Now, depending on varying circuits, some judges will read the jury verdict, or the jury foreperson will read the jury verdict. It just depends on the practices. All right, so we have gone through the trial process, kind of looked at each of the actors, what they do during that process. So you should have a pretty firm understanding of what to expect during a criminal trial. I wanted to make sure that we highlight capital cases. So capital cases are handled differently in state and federal courts because of the potential outcome. With capital cases, the defendant faces execution if convicted. So these are death penalty cases. And because they're death penalty cases, there are different standards and different kind of nuances that you have to take into consideration with these cases. So your typical capital cases encompass first-degree murder, treason, murder of a federal agent or politician, and some crimes against children. Again, these are death penalty cases. So there are some important differences between capital cases and regular criminal cases. The first major difference is if a prosecutor is going to seek the death penalty and raise the criminal case to a capital case, then they have to file a notice of their intent to seek the death penalty from the beginning. That way the defense and the defendant knows what is on the line. Now, during voir dire, which is, remember, the jury kind of questioning phase of potential juries during jury selection, attorneys have to ascertain if prospective jurors are death qualified. So what does death qualified mean? That means, is this person suitable to serve on a case where the punishment may be execution? There are some people who will say, I will never be able to sentence someone to death, or I strongly oppose the death penalty, it should be abolished. Well, prosecutors will probably not want those people on the jury because it could lead to a hung jury or a deadlock jury. So in the voir dire phase of jury selection, the prosecutors and the defense attorneys will be asking questions to truly kind of make sure that the prospective juries are able to truly serve on a death penalty case. Juries are more likely to be sequestered, which means taken out of their normal surroundings and isolated. You're typically going to see the trials being bifurcated with capital cases. So your first trial, your first part of the trial will be your actual trial, your presentation of evidence, all of that. And then once the defendant is found guilty, you will have a second part of the trial to establish the sentence. capital cases require unanimous verdicts from the jury, which means every person on the jury has to agree that that person is guilty. And there is a mandatory appeals process for all capital cases. So those are your main differences with capital cases. So now we're going to talk about sentencing. And I want you to take a minute, put down your pen, put down your paper, and close your eyes. I want you to ponder on this question. Why do we punish? What is the purpose of punishing someone who has violated the law? We've talked a little bit about this in our first weeks together, but the sentencing portion of a trial its entire purpose is to punish. But why? Truly ask yourself, why are we punishing people? Well, we're going to talk about the goals of sentencing and why we're punishing people during this section. So, sentencing is essentially the application of criminal sanctions to legally guilty individuals. So there are three main principles to punishment. The first is punishment has to be proportional. So the severity of the sentence must match the severity of the crime. In criminology, you will learn about the classical school of criminology and the different schools of criminology. And one of the tenets of our classical school is kind of calling into question the purpose of punishment and the purpose of sentencing. Caesar Beccaria basically wrote of crime and punishment to call out disproportionate punishments in medieval times. And so we take the principles that he laid out through today, because in order for punishment to be effective, it has to be swift, it has to be proportionate, and it has to be certain. And so the person has to know that they're going to get punished for disobeying the law. They have to know that they're going to be fairly handled within the system, and they know that if someone else committed the same crime, that the seriousness of the crime kind of dictates the seriousness of the punishment. So you have proportionality, which is the severity of the crime matches the punishment. You have equality, meaning that similar crimes are punished similarly. And then you have this notion of social debt. And essentially, this says that the purpose of punishment is to repay society the debt that you incurred for committing the crime. Now, those are your three main principles of punishment. There are 5 primary goals of punishment and goals of sentencing. So the first goal is retribution. The next goal is incapacitation. The third goal is deterrence. The fourth goal is rehabilitation. And the fifth goal is restoration. Now, let's talk about this for a minute. Retribution has been a hallmark of criminal justice practices dating back to the beginning of time. Someone wrongs us, we want to make them pay. That is retribution. That is a philosophy of punishment that permeates throughout our criminal justice system. Another primary goal of sentencing is to incapacitate the person who wronged us. So as part of the retribution or getting even or making someone pay for their crime, we need to take them out of society and incapacitate them. In doing this, we want to deter anyone from committing the similar crime or deter that person from committing another crime. You will learn about the deterrence theory in criminology if you go that far. And essentially the deterrence theory states that punishment, the purpose of punishment should be to deter any future crime of both the individual and the society in general. And so a purpose of sentencing is to deter an individual from ever wanting to commit a crime again because of the retributive nature of the punishment, but also to deter the community as a whole from going down a criminal route. There is a couple of new philosophies that have kind of grown in recent times around punishment and sentencing that makes us kind of second guess that retribution aspect of punishment. So the next goal of sentencing is based on the philosophy of rehabilitation. So yes, we should get even, make them pay for what they have done, but there's a growing body of knowledge that says that people who turn to criminogenic traits have some societal deficit. And so whether that be lack of opportunities for education, housing, anything like that that makes them turn to crime to meet their needs. The purpose of rehabilitation and incorporating rehabilitation in our sentencing basically focuses on putting the missing pieces together so that when that person gets out, they are able to then go about their lives as productive citizens. And then there's this whole notion of restorative justice, which really truly focuses on the victim and the harm to the victim. And essentially restorative justice says that that the victim needs to be restored to a place where they were pre the crime occurring. And so with restoration, that may include the offender having to pay what's known as restitution, which is monetary sanctions that they have to repay to the victim, or do community service, things like that. So your 5 primary goals is laid out there: retribution, incapacitation, deterrence, rehabilitation, and restoration. So now that we kind of have talked about the principles behind sentencing, let's talk about the types of sentencing there is. There are 2 types of sentencing that are available, and one is used pretty frequently. It's really kind of become the norm. But the 2 types is indeterminate sentencing and determinate sentencing, or structured sentencing. I'm going to start with indeterminate sentencing. And indeterminate sentencing was a common practice pre-really 1970s. And indeterminate sentencing basically allowed for judicial discretion in sentencing. And it focused on rehabilitation. And so sentences could range from years and had stated minimum and maximums, You had parole boards that really were empowered to kind of look at the characteristics of the offenders and kind of what they've done in prison and could operate to let them out on parole, and all of that. So judicial discretion was a key component of indeterminate sentences. The judges had the discretion to choose the sentences for the crimes within certain parameters. However, we started to see a lot of bias creeping into this. And you saw a lot of racial discrimination. You saw a lot of gender discrimination. Because when we allow discretion, you're ultimately allowing for bias. It's human nature to be biased. And so in a call to action around the 70s, we attempted to legislate sentencing. And we did that through what is known as structured sentencing guidelines. And you will hear me call structured sentencing determinate sentencing. It's another name for structured sentencing. Your book uses structured sentencing. But basically, structured sentencing is sentences are generally given in the form of fixed terms with anticipated dates of release. So this is a far more impersonal sentencing methodology. It removes discretion and really kind of shifts away from rehabilitation to retribution. It removes an offender's motivation to participate in programs as a means to shorten sentences, because this is where you start seeing mandatory minimums and three-strike laws and things like that. These sentencing types are established by legislative statute and rules, and it increases the likelihood that offenders are imprisoned and increases the length of their sentencing. So when we start, it's very common now in our practices, in our sentencing practices, to use structured sentencing. In fact, at the federal level, they have federal guidelines that they have to go by. And I'm going to show you sentencing guidelines. Your book has sentencing guidelines in it that I'll show you a picture of that's really kind of good. But the philosophy of sentencing really kind of goes back to, what do you believe the purpose of sentencing someone is? If you believe that it's for retribution, then structured sentencing or determinate sentencing is probably something you're going to typically agree with. However, structured sentencing has led to a lot of overcrowding in our prison system and has really been common and popular since the war on drugs. I talked a little bit about this with the structured sentencing, but with structured sentencing, we see mandatory minimums in place, and basically that states that's a legislative addition that basically states that here is the minimum amount of time for certain crimes. It does not allow discretion or alternative sanctions, and it's a foundational tenet to structured sentencing. Mandatory minimums typically come in the form of sentencing guidelines, and sentencing guidelines are grids that basically help judges identify the appropriate sentence for the offender based upon the severity of the crime and their criminal history. It's generally followed, but it's supposed to be advisory. So it's not supposed to be literal. Judges are supposed to be able to operate within the sentencing guidelines, but we do see that they're pretty generally followed. There are a couple of foundational laws that you have to be aware of in terms of sentencing and kind of structured sentencing. The first is the Federal Sentencing Guideline Act of 1984. This eliminated federal parole release for prisoners and abolished almost all good time earned. So please know that this is a federal law. So under the Federal Sentencing Guideline Act of 1984, federal parole became non-existent. It did allow release to supervised U.S. probation officers, but it really kind of curtailed good time earned incentives and things like that. Various states have what are known as 3 strikes laws. I'll let you look up Georgia to see if we have a 3 strikes law. You might be kind of surprised by what you find. But these are laws that enforce mandatory minimums by mandating long sentences without parole if someone is convicted of a third offense of the same offense. And then you have the Violent Crime Control and Law Enforcement Act of 1994, which requires that prisoners serve at least 85% of their sentence in order for states to qualify for federal financial aid. So you see a requirement of 85% they have to serve 85% of their sentence, no matter what that sentence is, before they can go up for parole. Here is an example of sentencing guidelines that you can look at. I'm not going to go over them in detail. I just wanted you to be able to see. So you see it's a table. You look at the crime type over in the left-hand column, and then at the top on the right-hand side, you kind of see what their criminal history score is, and then go to where the offense meets the criminal history score, and that's their sentence, essentially. So finally, we're going to talk about some diversity in sentencing and kind of disproportionality in sentencing. Most felony defendants are sentenced in the United States are poorly educated minority males with roughly a mean age of 35.3 years. So through all of the research that we have found, you typically see that minority males are harshly sentenced in our system. They typically come from low income, poor education, didn't finish high school, and typically have a longer criminal history. Your book goes into more detail around the different types of minority classes and kind of where they rank at and things like that. So make sure you pay attention to that. But one of the most important things that you realize is that sentencing is highly discriminatory. And even in trying to formalize sentencing through sentencing guidelines, it's still discriminatory because of the characteristics of criminals and the reasoning that they turn to criminogenic behavior. All right, so that concludes this week. Please remember you have quiz 9 over chapter 9 that's due on Sunday, and your exam opens up on Friday, and you can only take it on Friday. So please make sure you take that. This presentation is time-stamped, so go back and review what you need to, and I will see everyone next week. Thank you.